guys, welcome to today's Legal 101. Being a Wednesday, it's on family and succession law. What we're discussing today is distribution of residuary property, and we are borrowing from a judgment that was delivered by the Court of Appeal judges Wasame, Laibuta, and Mativo this year. And perhaps before we go into the facts of the case and the determination of the court, we should discuss what residuary estate or residuary property is. Now, if you write a will but you do not include certain properties in your will, those properties are deemed residuary property. If you have a residuary clause in your will, then those properties can go under that clause. And in your clause, you'll probably be saying everything that I have not included in this will be bequeathed to so and so, or will go into doing XYZ. Then in that case, those properties would be dealt with under that clause. Okay? But if you do not have that clause, those properties that have been left out of the will go under intestacy. Okay? Another instance where a residuary clause would come in handy would be where you have bequeathed property to a particular person, but the gift fails. For example, they die before the testator does. The residuary clause would come in to take care of that situation. But if there is no residuary clause, that property would go under intestacy. So in this particular case, a man named Mr. Shah had 3 daughters. He prepared a will in 2005 and proceeded to live on for many years after that. The probate process began in 2013. One of the properties, we're going to call it the General Madenge property, was a subject of this appeal. And the issue was that in the will, he had bequeathed it to his 3 daughters in equal share. But when he was still alive, he transferred 2/3 of his share in the property to 2 of his children, Rupal and Raki. Sorry to the Indian community if I have butchered the names. So that's what happened when he was alive. So upon succession, his 3rd child, Sejal, said, this 3rd should go to me. In the will, you can see that my father wanted this property, which is our family home, which holds sentimental value to all of us, to go to all 3 of us in equal share. That he had transferred 2/3 of his share to the 2 daughters does not mean that their 3rd should also be distributed among all 3 of us. Okay, their 3rd should go to me. So that was the subject of appeal before the Court of Appeal judges. And so the Court of Appeal said this, that this entire property was residuary property, looking at the way in which he dealt with it when he was alive. It was in the will and disposed 2/3 of it to his children. So the entire property was deemed residuary property. So the court said, what does the will say about residuary property? And the court found that he had indicated that it would go to his wife, all residuary property would go to his wife, but in her absence, all residuary property would be distributed to his children in equal share. The wife had passed away already, and so it had to go to the 3 children equally. So that was the determination of the court. The General Madenge property was residuary, and it would be distributed in equal share to all the 3 children. Okay, we will be exploring more on this issue of residuary property as we go along, because it has some layers to it. But that is the extent of today's Legal 101. I hope you enjoyed it. Please share this with your family and friends. Share this with your colleagues. Ask questions if you need to. Reach out in the DMs. Follow, subscribe to the YouTube channel. Yeah, see you tomorrow for tomorrow's Legal 101. Bye.